As Attorney General, I will continue to forcefully defend the independence of the Justice Department from improper influence or interference of any kind. And I will continue to fiercely protect the integrity of our criminal investigations. Nothing will deter me from fulfilling my obligation to uphold the rule of law. Fulfilling that obligation includes ensuring that the Justice Department respects Congress's important role in our democracy. That is why we have gone to extraordinary lengths to ensure that the committee gets responses to its legitimate requests for information. That is why I have provided the committee with Special Counsel Hur's report, why the Special Counsel testified for more than 5 hours, and why we have gone beyond precedent to provide the committee with the transcripts of the Special Counsel's interview with the President. But we have made clear that we will not provide audio recordings from which the transcripts that you already have were created. Releasing the audio would chill cooperation with the department in future investigations, and it could influence witnesses' answers if they thought the audio of their law enforcement interviews would be broadcast to Congress and the public. Now, in response, certain members of this committee and the Oversight Committee are seeking contempt as a means of obtaining, for no legitimate purpose, sensitive law enforcement information that could harm the integrity of future investigations. This effort is only the most recent in a long line of attacks on the Justice Department's work. It comes alongside threats to defund particular department investigations, most recently the Special Counsel's prosecution of the former president. It comes alongside false claims that a jury verdict in a state trial brought by a local district attorney was somehow controlled by the Justice Department. That conspiracy theory is an attack on the judicial process itself. It comes as individual career agents and prosecutors have been singled out just for doing their jobs. It comes as baseless and extremely dangerous falsehoods are being spread about the FBI's law enforcement operations. And it comes at a time when we are seeing heinous threats of violence being directed at the Justice Department's career civil servants. These repeated attacks on the Justice Department are unprecedented and they are unfounded. These attacks have not and they will not influence our decision-making. I view contempt as a serious matter, but I will not jeopardize the ability of our prosecutors and agents to do their jobs effectively in future investigations. I will not be intimidated, and the Justice Department will not be intimidated. We will continue to do our jobs free from political influence, and we will not back down from defending democracy. I look forward to your questions.
Mr. Attorney General, throughout the 118th Congress, Republicans have made bogus allegations claiming that the Justice Department has been weaponized. Most recently, there was an allegation that the FBI was authorized to, quote, kill the former president. What impact does this type of rhetoric have on the career prosecutors and law enforcement agents at the Department of Justice?
This is dangerous. It raises the threats of violence against prosecutors and career agents. The allegation is false. As the FBI has explained, the document that's being discussed is our standard use of force protocol, which is a limitation on the use of force and which is routinely part of the package for search warrants and was part of the package for the search of President Biden's home as well.
So when former President Trump alleges that this was an assassination attempt against him, he is not telling the truth, either knowingly or, as is often the case with him, unknowingly.
I'm just saying that the allegation is not true. This is our standard use of force policy, which limits the use of force that agents can use. It is used as routine matter in searches. That was a court-authorized search. and it accompanied that package as it routinely does. All of the reasons that Congress has given us for why they need the audio are satisfied with respect to the tapes. That is, all of the legitimate reasons given, the reasons that relate to legislative work of the committee. As to that, provided Mr. Hur's testimony in full, and we've provided Mr. Hur's report. We've gone as far as we can go to accommodate. We're trying to protect our ability to do investigations in this case and in any other case.
Mr. Attorney General, let's set the facts straight here. And my job is to kind of lead an intervention for my colleagues. I think they need it. The Attorney General did not prosecute Donald Trump in New York. It was the result of Donald Trump's choices. Donald Trump chose to live in New York. He chose to commit his crimes in New York. He was afforded a right to be tried by his neighbors, jurors, in New York. He chose that jury in New York, working with his counsel, and they chose to make him a 34-time over convicted felon. But some of the choices the department has made in the recent years is that the president that was first appointed, that Donald Trump appointed the U.S. attorney who is investigating the current president's son. Donald Trump appointed John Durham, who investigated the wild claims made by this committee during the Russia investigation. And Donald Trump appointed Robert Hur, who was kept on by the Biden administration. Also, you have the right in our country to aid yourself in your own defense and talk to investigators. You also have a right not to. Mr. Attorney General, did Donald Trump sit down for an interview in the Mueller investigation?
I actually don't know, but I'm not going to comment on other investigations.
He didn't. Did he sit down for an interview with investigators prior to the January 6th indictment?
I'm not going to comment on
He didn't. He also didn't sit down for an interview with investigators in the classified materials indictment, but President Biden did sit down for a voluntary interview with Robert Hur. A jury can't hold it against Donald Trump that he did not testify in his own defense in New York, but he promised everyone else in the country that he would. You can hold it against Donald Trump that he did not testify when you consider whether you should so blindly follow every wild claim that he makes. My colleagues, none of this today that you are bringing makes sense. Your inconsistencies, your hypocrisy, your sycophancy, unless you are in a cult. And guys, I'm starting to think you're in a cult. That is your right, but it's not your responsibility. I promise you that's not what your constituents would want. So if you believe in states' rights, except when a jury in that state convicts your nominee for president, you might be in a cult. If you claim you back the blue but want to defund the police when the police go to your nominee's house to retrieve national security secrets, you might be in a cult. If you're supporting a guy whose felony convictions prevent him from getting a security clearance, you might be in a cult. And if the guy you're supporting for president has felony convictions that prevent him from going to Argentina, Australia, Brazil, Cambodia, Canada, Chile, China, Cuba, Dominican Republic, Egypt, Ethiopia, Hong Kong,
my motion
India,
takes precedent.
Indonesia, Iran, Ireland, Israel, Japan, Kenya, Macau, Malaysia, Mexico, Morocco, Nepal, New Zealand, Peru, Philippines, Singapore, South Africa, South Korea, Taiwan, Tanzania, Tunisia, Turkey, Ukraine, United Arab Emirates, and the UK.
The gentleman from Kentucky is recognized for 5 minutes. I'm asking that the gentleman.
I have unanimous consent request.
The gentleman has unanimous consent request.
I ask unanimous consent to submit for the record an amicus brief by the former Attorney General Edwin Meese